There is a widely held perception among foreclosure defense attorneys and those attorneys that are pursuing the interests of consumer justice that our state court system is no longer a fair and equitable place to seek out the interests of justice on behalf of consumers, particularly in the case of foreclosures. Now, there is no question but that the state court system is right now engaged in a very aggressive program to clear foreclosure cases. What we're experiencing on the ground level is that the interest of clearing these foreclosure cases is being put ahead of the interest to due process and justice. I'll give you a real clear example of something that happened to me this week. For more than a year, I had been pursuing documents and evidence from a bank that was suing my client, and very specifically, very targeted discovery, asking them to produce evidence of the default letter and that it was sent. Many hearings, an extraordinary amount of taxpayer dollars and resources had been spent with me going to hearing after hearing in front of judges and demanding that the bank produce those documents. Now, in these many hearings that we had, the judges ordered the banks to produce these documents, and still they refused to produce the documents. The final order that was issued out of a judge was that the bank wouldn't be able to introduce evidence of those default letter because they had refused over a year to produce the default letter. Well, you can imagine my disgust when at the trial, when it was finally held, the judge ignored that order, and after more than a year of trying to get this evidence, the judge allowed the bank to produce the evidence that we had sought for more than a year in absolute defiance and contradiction of an order that had been entered. It's a turning point in my career because I clearly experienced a court system that was not willing to stand up for the interests of justice or for consumers, especially when, in face of its own orders, the court was not willing to hold a bank accountable for abuses, discovery abuses that they've been engaging in for more than a year. That's just one very timely example of what's happening all across the state. There's, of course, many more of them. So, in the face of what we see and are perceiving as a direct conflict and an unfair circumstance, we have to change our tactics and strategies. And to do that, we are increasingly going to be moving into federal court. With that example, and I would compare that to would they get away with that in federal court? Would a bank be allowed to ignore discovery, reasonable discovery, targeted discovery for more than a year and then come in front of a federal judge and say, we're going to go ahead and proceed on that claim anyway. We're going to ignore the orders that you had previously entered, and still we want you to allow us to pursue that claim. I'm quite confident that that absolutely would not happen. What we do see in federal court, here in the 11th Circuit, and frankly across the country, is an increasing focus on the rights of consumers and consumer justice issues, particularly in the space of debt collection. The 11th Circuit has issued numerous opinions recently, the 6th Circuit, 3rd and 4th, affirming the rights of consumers to defend themselves and to pursue claims for fair debt collection practices and other violations. So we are going to be shifting increasingly to bringing these claims into federal court, both as independent actions and then especially in the context of bankruptcy proceedings. Now, again, consider what would be happening in state court where repeatedly, systematically, banks are engaging in discovery and abusive practices and getting away with that. And then we're going to compare whether they would be allowed to engage in those same tactics in federal courts. Dare say that would not occur. So increasingly, consumers need to be looking to federal courts, bankruptcy, and then pursuing independent claims to hold the banks and the debt collectors accountable. As we evolve in this fight against the banks, we have to take the fights into different areas. And increasingly, of course, that does mean bankruptcy courts, which provide extraordinary protections for consumers. And I quite frankly really welcome the opportunity to take the evidence that we've gained in state court proceedings, specifically in cases which then would be moved into federal court proceedings, and then compare the conduct of these banks and these creditors that they engaged in state court proceedings, were quite frankly allowed to engage in abusive conduct, with the conduct that they may engage in federal court proceedings, especially when the protection of the bankruptcy courts apply and the federal rules regarding discovery and their abusive tactics comply. So I encourage you to participate in this fight by bringing claims to us, allowing us to examine the conduct of debt collectors, allowing us to examine the claims that they are submitting, and seeing what we can do to help protect you and the rights of consumers generally.